The types of arbitration and their benefits. Arbitration is a process that helps people resolve disputes outside of the court system. There are different types of arbitration, each with its own benefits and drawbacks. Let's take a look at the different types of arbitration and see which one might be right for you. 1. What is arbitration? And what are the benefits of using it instead of going to court? Arbitration is a type of alternative dispute resolution adder in which two parties agree to have their dispute heard and resolved by an arbitrator instead of going to court. The arbitrator is a neutral third party who will listen to both sides of the argument and then make a decision. This decision is binding, meaning that both parties are required to comply with it. Arbitration can be used for a variety of disputes, including those related to contracts, employment, property, and insurance. One of the main benefits of arbitration is that it is typically faster and cheaper than going to court. In addition, arbitration can be less formal than court proceedings, which can make it more comfortable for some people. Finally, arbitration offers flexibility in terms of scheduling and location, which can be advantageous for parties who live in different areas or have busy schedules. Overall, arbitration provides benefits that make it an attractive option for resolving disputes. 2. What are the different types of arbitration and how do they work? There are different types of arbitration, each with its own advantages and disadvantages. Here are some of the most common. Binding arbitration is the most common type of arbitration. In this type of arbitration, the arbitrator makes a binding decision that both parties must follow, and this can be advantageous because it avoids the need for a trial. But it can also be disadvantageous because it may not be possible to appeal the arbitrator's decision. Non-binding arbitration is less common than binding arbitration. In non-binding arbitration, the arbitrator does not make a binding decision instead. They merely offer their opinion on the matter. This can be advantageous because it allows both parties to reach a resolution without having to go to court, but it can also be disadvantageous because the arbitrator's decision is not binding. Mediation is another type of arbitration. In mediation, both parties meet with a neutral third party who helps them to reach a resolution. This can be beneficial because it allows both parties to have a say in the outcome, but it can also be disadvantageous because it may not be possible to reach a resolution. 3. What factors should you consider when deciding which type of arbitration is best for your situation? Commercial arbitration is a process used to resolve business disputes through the use of an arbitrator, who is a private, neutral third party. This type of arbitration is generally less formal than court proceedings and can be conducted without the need for attorneys. However, it is important to consider the following factors before deciding if commercial arbitration is right for your situation. First, consider the severity of the dispute. If the dispute is complex or involves a large amount of money, you may want to consider using a more formal process, such as court proceedings. Second, consider the relationship between the parties involved. If the parties have a close relationship, such as in a family-owned business, commercial arbitration may be more likely to result in a positive outcome. Finally, consider the cost and time commitment involved in commercial arbitration. This type of arbitration can be expensive and time-consuming, so be sure to weigh all of these factors before making a decision. 4. How can you prepare for arbitration and what should you expect during the process? When two parties in a dispute are unable to reach an agreement, they may opt for arbitration as an alternative to going to court. Arbitration is a process in which a neutral third party hears both sides of the argument and makes a binding decision. While arbitration can be faster and less expensive than going to trial, it is important to be well prepared before entering into the process. It is advisable to consult with an attorney before beginning arbitration, as they can help you understand the rules and procedures. Once you have a clear understanding of the process, you will need to submit a written statement of your case to the arbitrator. You will also need to disclose any documents or evidence that you intend to present. The other party will have an opportunity to do the same. During the arbitration hearing, both parties will have the opportunity to present their argument and call witnesses. The arbitrator will then make a binding decision, which can typically be appealed if either party disagrees with the outcome. 5. Are there any risks associated with arbitration, and how can you minimize them? Although arbitration is generally the faster and more efficient way to resolve disputes than going to court, there are some risks associated with this process. First, arbitration is binding, which means that you give up your right to appeal the decision if you are unhappy with the outcome. Second, the arbitrator's decision is often final and cannot be overturned, even if it is unfair or made in error. Third, arbitration can be expensive, especially if you need to hire an attorney or pay for a professional arbitrator. Finally, arbitration can be stressful and emotional, as it can be difficult to predict how the arbitrator will rule on the case. However, there are some steps you can take to minimize these risks. First, make sure that you understand the arbitration process and what it entails before agreeing to participate. Second, do your research and choose an arbitrator who has experience with cases similar to yours. Finally, be prepared for the worst-case scenario by having a backup plan in place in case you are not satisfied with the arbitrator's decision. By taking these precautions, you can help to reduce the risk of arbitration and improve your chances of a successful outcome. 6. How does arbitration compare to going to court, and which option is right for you? Arbitration and litigation are two very different processes for resolving disputes. Litigation is the process of taking your case to court, where a judge or jury will hear your case and render a decision. Arbitration, on the other hand, is a private process in which you and the other party agree to submit your dispute to an arbitrator, who will then make a binding decision. So which option is right for you? There are several factors to consider when deciding whether to litigate or arbitrate your case. One is the nature of the dispute itself. If the dispute is complex, or if there is a lot of money at stake, litigation may be the best option. This is because arbitration is generally less formal than litigation, and may not provide the same level of discovery or opportunity to present evidence as a court proceeding. Another factor to consider is whether you want a binding decision. If you do not want to be bound by the arbitrator's decision, then arbitration is not right for you. Finally, you should also consider the cost of each option. Arbitration can be less expensive than litigation, but it can still be costly if you have to pay an arbitrator's fees. Ultimately, the best way to decide whether arbitration or litigation is right for you is to consult with an experienced attorney. They can help you understand the pros and cons of each option and make a decision that is in your best interests. Subscribe to my channel for more tips on legal disputes and how to resolve them.